Welcome to class 20 of Secretarial Practice. In the last class we were discussing about articles of association, its meaning and the contents of articles of association. So in this class we'll study regarding the alteration of articles of association. So what is this alteration? Alteration is nothing but you are going to change. What you are going to change now? The rules, regulations you are going to change, because the articles of association is a document which contains the rules and regulations, right? So here, this alteration power to alter the articles, this alteration power is given by the Companies Act itself. So what it says, the company can enjoy the power to alter its articles to suit its requirements from time to time, which means the situation what is prevailing, so that do not remain the same. It changes from time to time. Okay, so in the beginning itself, when you are going to start the company, you may have a particular object which is mentioned in the memorandum of association, and the present situation what is there, so that situation is not supporting you to achieve that. Okay, so what you are going to do, you have to adjust according to that situation. So you cannot change the memorandum of association. So what you are going to change now, so the way to achieve that object you are going to change, right? Which means the rules and regulations what is there in the articles of association, so that you are going to change. So section 31 of Companies Act states that the company may alter its articles by passing a special resolution in the general meeting and file the same with the registrar within 30 days. So it says the process to change the article is the company should conduct the general meeting, and in that general meeting you are going to pass the special resolution, and the resolution copy you are going to file it with the registrar within 30 days. So this becomes your alteration. So we can say you have altered your articles. Okay, so the effect of change must be clubbed in all copies of articles issued after the date of alteration. Okay, so I said in the beginning that it is a power given by the Companies Act itself to change the articles, which means it is a statutory power given by the Companies Act, and this power cannot be taken away by any provision either in the articles or in the memorandum. Okay, so even though the memorandum says that no, you cannot change the articles, even then you can change it, because the power is given to you by the Companies Act itself. Because whatever memorandum you are going to prepare, so you are going to take the Companies Act as a basis. Okay, so Companies Act is above your memorandum. So the Companies Act itself is saying you that you can change your articles. So whatever contained in the articles of association and memorandum of association, so such provision cannot take away that power. Okay, once the alteration is done, so you have to file it, or within 3 months of passing the resolution you have to make the changes and file it with the registrar. The next is conditions. So simply the powers are not given, so the powers are given along with the implied conditions. So some conditions are been there. So what are those conditions? So first condition is it should not violate the provisions of Companies Act. Company Act has given you the permission to change the articles. So now whatever articles you are going to prepare, so you have to take into consider the Companies Act's provisions. So whatever provisions are there in the Companies Act, so such provision should not be violated, or you should not go against such provisions. The next is articles should not go against your memorandum, which means in the memorandum we have a certain object, and the rules and regulations or the articles what we are going to change, so that should not make effect on the object, which means we cannot change the object there. That should be similar or that should be the constant one, and only the rules and regulations you have to change here. So it should not go against your memorandum, or whatever it said in the memorandum you should not go against it. The next is, it should not sanction any unlawful things, which means whatever articles or whatever changes you are going to make in the articles of association, it should not be unlawful or it should not be illegal. The next, it says special resolution should be passed. So here when you are going to alter, you should pass the special resolution. So ordinary resolution should not be passed here. So if you are simply passing the ordinary resolution in the board meeting and you are going to alter, so no. So you have to conduct a general meeting, and in that general meeting special resolution should be passed, and only this resolution is going to give or may help you to change the articles. The next is, cannot seek to impose additional liability of members without the written consent, which means suppose you are going to alter the articles, and in that articles and based on that articles you are asking the members, or you are going to increase the liability of the members. So in such case, so what happens, it is not valid if it is not, or if it is without the written permission of the members. So whatever you do, if you want to increase the liability, you can increase it by taking the written consent of the members. So it is mentioned that the liability of members may be increased either by asking him to buy more and more shares, or pay for the more shares already taken. Okay, suppose if the company is going to ask the members to buy the more shares, or they may ask, you have previously paid for the share and you have to pay more for the same shares. So in such case what you have to do is, you have to take the written consent, or you have to take the agreement, or the members should agree in writing. The next is benefit of company as a whole and should not constitute a fraud on minority. So there is a case called as Cook versus Deeks case. So that case I am going to explain you in the next class. So in what is this, or what does this point speaks about? So whatever alteration you are going to do, it should not be for the benefit of the employees who are working there. Okay. So whatever you are going to do, it should be for the benefit of the company itself. So your personal interest should not be included here. The next is, it must not be inconsistent with an order of the court, which means whatever the court says, it should not go against that. The next is, the alteration should not cause a breach of contract with outsider. Suppose, for example, we have preliminary contract as a content, or preliminary agreement or the contract as a content of your articles of association. So which means you have entered with the third party, or you have entered into an agreement with a third party, and if you are going to change the articles, so that changes should not affect, or that should not lead to the break of contracts. The next is get approval by central government. So in some cases you have to get approval or permission from the central government. Suppose if you are going to convert your company, public company into private company, or if you are altering relating to the appointment and reappointment of managers, managing directors, or the directors not liable for the retire by rotation. So directors retire by rotation and all I am going to teach you in the next chapter. The next is any alteration resulting in an increase in the remuneration of directors or managing directors. So in such cases, what you have to do? You have to take the permission from central government. The next is secretarial duties for alteration of articles. So what is the duty of secretary here? So as a secretary is going to convey the board meeting. So before you are going to convey the general meeting, you have to conduct the board meeting, and in this board meeting you are going to fix the date, time, place and agenda. So of what? Of general meeting. Then the next is you have to see whether the articles of association is not against the provisions of your companies act, not against the provisions of your memorandum, because so these two documents, or memorandum is the document superior to articles of association and the memorandum is prepared on the basis of companies act. So these two are the superior to these articles of association, so that it should not surpass these acts. So the next is prepare and send notice. So you are going to prepare the notice for the general meeting and send it to all members at least 21 days before meeting. The next is you are going to make a necessary arrangement for the meeting. The next, get resolution passed. Which type of resolution you are going to pass here? Special resolution, right? The next is whatever resolution you have passed in the general meeting, so that resolution you have to file it with the registrar within 30 days, and after that whatever alteration you have done, the altered copy of memorandum of association is also to be filed it with the registrar within 3 months from passing, within 3 months of passing the resolution. And you have to see that all the changes what you have made, so that is been clubbed in all the copies of articles issued after the date of alteration. So thank you.